Sidebar, Bracewell's podcast devoted to government enforcement investigations, corporate compliance, and white-collar criminal defense. I'm Matthew Nielsen.
And I'm Seth DuCharme.
And we are your host and both partners at Bracewell LLP, where we represent companies, boards of directors, and individuals in all manners of litigation, investigation, and enforcement actions.
Well, good afternoon, Matthew. I'm looking forward to today's conversation about search warrants, which has been an item, I think it's fair to say, that's been on top of the headlines given some recent events. And there's probably a fair amount of curiosity in our listening audience about how one gets a search warrant, what it requires, and what inferences can be fairly drawn from the existence of a warrant.
Yeah, I mean, I think you and I were talking and put the cards on the table. You know, there's been lots of news about the search warrant that was executed on the former president's home in Florida. And we're not going to get into politics and we're not going to get into necessarily any specifics relating to that matter. There's a lot still to come out, and maybe that'll be part of a discussion for a future episode. But you and I were disconcerted with all of the misinformation out there just generally on what is a search warrant and what does it take to get a search warrant. Some reports have been better than others on how that works. And so just kind of stepping back and saying, well, let's cover that topic. Let's talk a little bit about the process of getting a search warrant, what's required. Logistically, how do you go about getting one in the federal system? And we could talk a little bit about, how to deal with search warrants involving, maybe high profile people or matters, very generally speaking, to remind our audience, Seth was what I would view as in the higher levels of the Department of Justice during the last administration, the assistant to the Attorney General, and then the principal associate deputy Attorney General. So kind of certainly can't talk about any specifics, but involved in some pretty high profile matters during his time as a prosecutor.
Yeah, I appreciate that, Matthew. And honestly, my education in search warrants came in, early on in my career as a prosecutor, the much less high profile stuff, but just the work of investigating cases and obtaining evidence. So, most search warrants that are executed across this country every day receive, little or no attention from the public. They are a quite common investigative tool, although frankly, quite an intrusive one. So, I also, as I was mentioning to you, even if we didn't want to talk about this topic, it seems inevitable because it's truly become kitchen table conversation, barbecue conversation. If you're a lawyer of any kind, you're likely to run into a question from a friend or family member, what should I make of this? And so that's why I fully agree with you. It's certainly worthwhile of our conversation. I think the starting point probably makes sense with the Fourth Amendment to the Constitution. You have a right to be free of unreasonable searches and seizures. And there is no general warrant under the U.S. Constitution. Law enforcement authorities cannot go into a person's residence and search for evidence without that search being blessed by a judge. And that requires a showing of probable cause that evidence of specific crimes are likely to be found, will probably be found, in fact, in the residence. So it's a particularized requirement. There's judicial oversight. You have to state what crimes particularly are being investigated and the facts that you allege that amount to probable cause. And then there's a limitation to the scope of that search. It can be expanded if certain events unfold, but initially a warrant can only be executed within the scope that the judge authorizes.
Yeah, that's a great review. I mean, it is the most intrusive way of gathering evidence from a subject or target of an investigation. I mean, the other ways, quite frankly, you could have voluntary production of information, whether that's voluntary statements or voluntary production of documents. And people may laugh, but that happens all the time in a federal system because sometimes lawyers, we believe that it is in our client's best interest to cooperate with the investigation if we don't believe there is a crime or we believe that cooperation will result in better outcome for our client. Another way of getting it is through a grand jury subpoena that is issued. There has to be a grand jury that's been impaneled, subpoena for documents. But talk a little bit, Seth, about the decision. And I think, again, we're not going to get into the specifics of this case, but the news has been there was, I think, both grand jury subpoenas and a search warrant. But when you're going through that decision as a prosecutor or maybe the question would be well, then why don't you just do a grand jury subpoena? Sure. Why do you go to the level of doing a search warrant? And talk a little bit about what's the thought pattern there on which of those to engage in.
Sure. Well, I think they're reasonably related. The burden of proof by which The government must establish cause to use the instrument of the search, whether it's a grand jury subpoena or a search warrant. The burden is lower on the government to issue a grand jury subpoena, much lower than it is to issue a search warrant. And that relates to both the intrusiveness of the search and also the richness of the contents of material that you're likely to obtain through the process, and also who holds the information. So, for example, grand jury subpoenas are most often used for things like phone records, where a third party, the phone company, holds those records. The information may be limited. It may be numbers called or numbers received. And so the scope of the intrusion is limited. The reasonable expectation of privacy on the part of the subject is less because of the involvement of a third party. And the substance of the information is less. You can certainly draw inferences from who called who when, but you don't see deeply into the life, of the subject. And Fourth Amendment, and in particular search warrant jurisprudence, has evolved over time as technology has evolved. So what we used to kind of, what I at least used to think of as phone records, and in fact, when I started as a prosecutor, phone records meant just that. Who did you call and when did you call them? The way phones operate now is essentially, one of my friends refers to a phone as a tracking device that makes phone calls. These phones collect a tremendous amount of information about people, geolocation information, web browsing, all sorts of information. And so the Supreme Court has now recognized that, for example, to get geolocation information about someone, which essentially permits authorities to put together a pattern of life for that person, which is really intrusive if you think about, the government knowing where you go, how long you spend there. That now triggers a warrant requirement because of the nature of and scope of the search and the expectation of privacy that a person has in their daily movements. So there has been some evolution in jurisprudence relating to what will require a warrant and what will not. Staying focused on search warrants in particular, a search warrant, I think when we talk about a residence, the courts have long recognized that a person enjoys a greater expectation of privacy in their home, much more so than they do in a public place or in a car on the highway. And so when you're talking about searching someone's home, absent truly exigent circumstances, like chasing an armed robber into their house, there are some limited exceptions for when law enforcement can enter a house. But if you're going into the house for the purpose of searching the house for evidence, warrant requirement is clearly implicated. And I think that goes to both the scope and intrusiveness of the search. Inevitably, in searching for one thing, you will come across other things that may not be evidence of a crime, but which are fairly seen as private. And so the court balances the needs of the government to be effective in law enforcement with the privacy interests of an individual in their home.
Yeah. And so let's talk a little bit about what it takes, the process of getting a search warrant. And then we could talk a little bit about what a search warrant looks like and what it allows. And for people that are interested, the warrant that got this discussion going has actually been released to the public. That's often not the case this early in an investigation. And so it doesn't tell you a whole lot, but it does show you some interesting information. But let's just step back and talk a little bit about the process. I mean, you mentioned earlier, probable cause is the standard.
Right.
In our criminal system, that's one of the lower standards that there is. It's, everybody's familiar with, to convict someone of a crime is beyond a reasonable doubt. That is a very high standard. It is a lot higher than what you would require in a civil case, any kind of civil case at any level. But to get a search warrant, it's probable cause, and there's lots of different definitions, but it's facts that would lead a reasonably prudent person to believe a crime has been committed. So how do you go about, let's talk a little bit about how do you go about establishing that, and procedurally, how do you just go about getting a judge to sign a search warrant?
Yeah. So I think it's important in saying at the outset that probable cause to believe that evidence of a crime will be found at a premises is different from saying there's probable cause to believe that the resident committed the crime. Sometimes they can overlap. They often do, but sometimes they don't. And so I think it's really important to stay focused on what a search warrant is and what it is not. A search warrant is probable cause to believe that evidence of a crime will be found in the premises to be searched. Whether or not the perpetrators of that crime are present is a related but different question. So sometimes you will see the government execute contemporaneously search warrants and arrest warrants. And there may be overlapping facts in those affidavits in support of those instruments, but they're not the same thing. And I think that when the government proceeds step by step, what they're doing is they are in sort of orderly, sequential fashion, collecting evidence to then determine if that evidence meets a charging standard and if that evidence supports allegations against a particular individual as being a perpetrator of the crime. So I don't want to devolve too much into legalese, but I think at its most basic level of understanding, that's a distinction that's really important to make, because the government executes search warrants on occasions when no one is arrested. And on other occasions, they execute arrest warrants and conduct searches incident to that arrest where evidence may be obtained. So I think it is, it's not fair to anyone to say because, your car was searched, you must be a criminal. No, it means that evidence of a crime, was likely to be found in your car or your house or your shed or your hotel room. To establish probable cause, the government has to allege under oath through an affiant, which is usually the case agent who's part of the investigative team, or it could be another agent on the team who has knowledge of those facts. The agent can essentially review the investigative file to allege those facts in the affidavit. So whereas at a trial, you'd have to call lots of witnesses, typically with direct evidence or knowledge of the crime, and that's how you put a trial together. To offer a search warrant, you basically have one affiant in the vast majority of cases. I'm only aware of one case, I think, where we had two affiants on the same affidavit, which is a little unusual. Typically, one affiant says, I've reviewed this information. I am swearing to you, right hand in the air, to a magistrate judge, typically is the authority that reviews the search warrant. I'm swearing to you that these are facts known to me, believed by me. And what you're shooting for, really, Matthew, is just crossing the line comfortably into probable cause. So you don't have to allege every fact of which you're aware. You just have to allege facts that will give the magistrate judge comfort that you are, well on the right side of the line. And those facts could be anything from information obtained through grand jury subpoenas, like phone records. It could be physical surveillance. It could be confidential human source information. It could be a whole sort of potpourri of information cobbled together, usually in numbered paragraphs, that by the time you get to the end, ideally a magistrate judge says, I am comfortable that you have established, you have met your burden, through this affidavit, and therefore I will grant you a warrant. The warrant is typically limited in the time during which it can be executed. Normally that's like 6 a.m. to 10 p.m.
Right.
And there's an issue of freshness in the warrant. So if the information is too stale, the magistrate may be sort of skeptical. If you say, well, we have a witness, 3 years ago saw this, sitting in the vestibule, the judge is going to say, well, it's kind of a long time. Why do we think it's still there now? And the judge may also set a period of time, usually 2 weeks, by which the search warrant must be executed. And this is all pursuant to Rule 41 of the Federal Rules of Criminal Procedure. So, if anybody wanted to sort of read for themselves what this process is, you can look at the rule. It involves judicial oversight. It involves sworn statements from law enforcement. And if it's ultimately used, it's subject to suppression motions, and it's fully litigated and challenged, and live witnesses are often called. And that's pretty routine in the criminal justice system. And I think just in terms of managing expectations, I, like many other people, when I saw the news alert that said, the department has unsealed the warrant, I forgot for a moment that there's a big difference between the warrant and the affidavit in support of the warrant. The warrant on its face provides quite limited information. The affidavit is really the substance of the probable cause. It's not surprising that in most cases, the government keeps that information sealed until it becomes an issue for suppression because of the sensitivity or potential sensitivity of the information. It's essentially a roadmap to a part of the government's investigation, and it may reveal sensitive sources or techniques.
Correct.
And so if no one's charged, then there's really no basis to move to suppress because there's no prejudice that arises from the seizure in the vast majority of instances. Unless you destroy the house in the process, you may be looking at a lawsuit for the damage that you caused. But there's no prejudice in the criminal justice system, nor should there be, because a search warrant.
Prejudice in the public view, though, right? I mean, that, as a defense attorney's been on the other side of those, having a search run at client's company. I mean, that creates huge PR issues.
Yes,
and there's not, like you said, usually these things are sealed, which means they're not, unlike most court records, they're not subject to public view.
Yeah, and
people are out there thinking, well, this company or this person must have committed a crime because the FBI showed up with all their blue jackets with the yellow lettering on it.
Yes, and indeed, while I've made this distinction, as you point out in the court of public opinion, it may be a distinction without a difference. Mm-hmm. I say, no, this is not probable cause that the resident committed a crime. This is simply probable cause that there's evidence of a crime in her house. And so, the neighbors may say, oh, really? Okay, well, the inference I'm going to draw, not as a juror having received a very strict, court instruction, the inference I'm going to draw as the neighbor is that, that my neighbor must be a crook because, as you said, the police have arrived. It's a little bit of a damned if you do, damned if you don't. Maybe I'm in the tortured position now of being a bona fide defense attorney now out for a year and a half.
Recovering prosecutor.
And being a recovering, prosecutor, because it's very hard to balance the equities. We know that defendants are, even when charged, are innocent until proven guilty. We also know that people draw some pretty negative inferences. We say arrest is probative of nothing, that a defendant remains presumed innocent all the way until the conclusion of the trial. But we know the reality of how people form opinions. But you might ask yourself, well, how do you execute a search warrant without causing the level of prejudice? And I mean, you could do it in the middle of the night when nobody's awake. But that also sort of has an air about, that there's problems with that too. We've seen instances of, police executing searches off hours, and that can lead to confusion, disorientation of the residents.
It's certainly more, in a residence, it's going to be much more dangerous. I think when you're talking about, the issue that I've faced is, have a corporate client that has a search warrant that's executed, and by just complete coincidence, the news media is sitting across the street, right, with their cameras ready to roll. And, it's hard to combat that. And, that's why a lot of times, usually in a corporate white collar context, you know about the investigation before there's certainly any kind of search warrant. And so that's a lot of times why we will just voluntarily cooperate and even offer that, your agents can come, don't need a warrant, just come inspect and gather what you want to gather. But you're right. I mean, it's, the problem is, you have these sealed documents. They mostly are sealed to protect the government, right? Because it does kind of lay out sources of information and lay out the game plan. It also helps, honestly, you could argue it helps protect the person, whose home or whose business has been searched, because there's plenty of times that searches are run and there's no prosecution that results from it, or not of that, maybe that person or of that entity. The affidavit, though, just so it's clear, the affidavit does have to show that there is, to believe there has been a crime that's been committed.
Yes.
And to show that there's evidence, there's probable evidence at the location to be searched. And so that's why, again, in this particular context, there's a lot of effort to get that search warrant affidavit unsealed. But that, my guess is that's going to be a tough road to go, because there's probably a lot of very sensitive information there.
Well, it is a double-edged sword, as you point out, because until there is a litigation underway, and by which I mean, an arrest and then the rights that attach to a defendant upon arrest, you really don't have a litigation forum to deal with the search warrant early on in an investigation. And so to unseal it publicly would leave hanging allegations from the government with no forum in which to answer. And so for claims to be fully and fairly litigated for both sides, there needs to be, an impartial judge or fact finder there to hear those. As things spill into the public record, even though we have an understandable appetite for the information, and at some point there is a public interest in unsealing, that's always balanced against other interests, the interest of the defendant, the interest of the government. But to simply unseal an affidavit early on in an investigation would leave hanging these allegations. You'd sort of really be between a rock and a hard place if you were the defendant.
That's right.
You'd be out there trying to rebut these things in the court of public opinion, which is not necessarily a fair and impartial court.
No.
And as you say, if sometimes the evidence leads to a prosecution, and sometimes it doesn't. So preserving the status quo as best as possible. Recognizing that as soon as the government does anything overt, that the scales, start to tip. I think it's probably obvious, but maybe it's worth repeating. It's not simply evidence of a crime will be found. It's evidence of specifically identified enumerated crimes. And if you find evidence of other crimes, you're supposed to go back to the judge. If you find something in plain view, I went in looking for evidence of fraud, and in plain view, I saw cocaine. So now I think there's going to be cocaine there. I'm not allowed to just expand my search and turn it into a drug investigation. I need to go back to the magistrate with the new fact, the lawful view of cocaine in plain view or whatever other contraband is discovered. I'm just using that as an example. But whatever other contraband is discovered may lead to the expansion of a warrant, or it may not, but you got to go back to the judge. So it's not a general warrant. It's not, I can go into the house and look for evidence of any crime.
Look for anything and everything.
But of course, in looking evidence for a specific crime, most types of evidence can be hidden in a lot of places.
Right.
So it's cold comfort, to many subjects when you say, oh, don't worry, I can only look for evidence of, wire fraud.
Right.
But I can pretty much look everywhere in the house for evidence of wire fraud. So your privacy interest is undeniably, intruded upon, unless you're searching for something, enormous, like a motorcycle in the living room, and you discover it your first step through the door. It's going to be a pretty exhaustive search.
Well, and there's sometimes that the warrant will be, usually if a residence, it basically says you can search the residence, but there are sometimes limited circumstances. Again, read the one that's at issue here with the former president. It will be more specific about what you can search, right?
Right.
You may only be able to search certain rooms. You may be prohibited in searching certain areas of a residence or of a building. And so, it's the warrant basically tells you when you can go, during what hours you can go, what you can look for, and where you can look for it. And if you go beyond any of that, you have an invalid search.
That's right. And it pays to be careful, because if a case is ultimately brought, the affidavit will be unsealed to the defense.
Right.
And if there are grounds to challenge the warrant or the execution of the search, then there will be a suppression hearing, and that search will be vigorously tested. So the government is highly incentivized not only to obtain the warrant carefully, but to execute the warrant carefully, or risk under the exclusionary rule the loss of evidence available to them to prove their ultimate case.
Well, and then we won't get into too much of this, but then there's this concept of, you gotta love it, it's the fruit of the poisonous tree too, right? And so if you execute a search warrant, you gather evidence illegally, and then you use that evidence then to gather additional evidence based upon that illegally obtained evidence. Everything you got from that will also be suppressed, unless you got it through some independent grounds. But essentially is, if you run a search warrant and you gather evidence unlawfully and it's early on in a prosecution, you run the risk of tainting your entire case and all the evidence.
Right. So look, in every case, the government should be careful, but particularly in high profile cases where they know there's public interest. I mean, everyone, no matter who they are, is entitled to the same standard of law and the same level of attention. But the government in a high profile case will certainly anticipate vigorous challenges. And so it can be expected to be, extra careful in the exercise of its powers.
Well, that's perfect. I think that's a great way to end. Seth, I appreciate jumping on here. This is great, I think, information for our listeners. And we will, after our little break here during the summer, we're going to get back to our regular schedule and continue to bring you information on hot topics in white collar, and then continue, having special guests on to talk about interesting subjects in white collar government investigations and compliance.
As always, a pleasure to be with you, Matthew.
Well, great. Well, thank you for listening to this episode. You can get this and other episodes of Sidebar everywhere that you get podcasts, as well as on the Bracewell webpage.